Good morning. Thank you for joining us for the Hot Legal Issues webinar. Our presenters this morning are Kathleen Dartez and Colette Massengale with Maryland Realtors. Are you wondering whether the new escrow agreement is required? Do you want to find out whether emotional support animals must be specifically trained or certified? Join us to get answers to these and other hot topics today. This webinar is part of the 2019 Maryland Realtors Webinar Thursday series and one of the free Maryland Realtors benefits. You can view the entire schedule on our website at marylandrealtors.org. Please hold your questions until the end of the presentation and we will answer as many as possible. Thank you, and let's begin.
All right. Good morning, everyone. I hope you can hear us. I'm Kathleen Dartez.
I am Colette Massengale. We want to welcome you to the Legal Hot Topics webinar.
All right. And we're going to try and keep this to an hour, so let's just go ahead and get started, jump into the first slide. We're starting with everyone's favorite topic, disclosures. The first question here, what is the seller's obligation to disclose the existence of any deferred water and sewer charges, often referred to as front foot benefits, to the buyer? What if the seller doesn't disclose? I think some of you are more familiar with this than others. Prince George's County and Anne Arundel County have had their own county rule regulations on this for a while. But the state of Maryland now, across the entire state, it is an obligation for the seller to disclose to the buyer the existence of any deferred water and sewer charges. Sometimes I'll call it a private utility charge or a front foot benefit. The consequence, if those charges exist on the property and the seller does not disclose it, there can be, can be some significant consequences. If the buyer finds out before settlement, which pretty much would mean if the title company discovers it in the title search, then the buyer can terminate the contract and would be entitled to receive their EMD back. If the buyer doesn't find out about it until after settlement, the seller would be obligated to pay it off, basically pay the entire thing, not just the $600 or $800 that might be due for that year, but the entire balance, which could be $20,000, $26,000. So you as a listing agent need to be particularly careful about this when you're going through the listing agreement. There is a paragraph in there which we modified recently. You should ask the seller if the property is subject to a deferred water and sewer charge, and the seller should check yes or no. And I would just caution you, kind of slow down and make them actually think about that and maybe look through their records to see if they really do have it. You don't want them to just forget or say, no, I don't think so, and just check no. Because again, if it's not discovered until after settlement, that could have a significant financial consequence for the seller. They would have to pay off the entire balance of what is owed on that. Is there anything else I should add, Colette?
Well, given what Kathleen said about the significance of the penalty, not only did the Maryland Realtors include it in the listing agreement, it's also a notice in the residential contract of sale. So it's another opportunity to have a discussion about this important disclosure.
Right. Good. All right. I think we're good on that.
Okay.
The next question is another disclosure question. My question concerns sellers who have installed home surveillance systems in the home and are able to record audio. Is this legal in Maryland? Is there any obligation to disclose this fact to prospective buyers? This has been a hot topic recently. We wrote an article in the magazine a little while ago about nanny cams, which is sort of what people were doing at that point. Now it's even more. I think everyone's got security camera and video on their front porch a lot of times as part of a home security system. So the law in Maryland is that you can record video. You can do a video recording of someone. You cannot do an audio recording unless you have that party's consent. They refer to Maryland as a two-party consent state, meaning the person doing the recording and the person being recorded would both have to consent to the recording. So in reality, your seller should not be making an audio recording while someone is in the home or visiting the home or at any point really in that process. Again, you can control your client only so much. We did modify the listing agreement to add a paragraph in there. So when you're going through a listing presentation or making a listing presentation with a seller, you should focus on that paragraph and make the seller aware that it is illegal in Maryland to do an audio recording of someone in the home. Again, you're going to tell them not to do it, and then I don't know. Yeah. In the perfect world, they would listen to you and they would not do it. In the real world, you're going to tell them that, make sure they're aware of it. And I think that's probably all that you can do in all honesty. On the buyer side, again, In the consumer notice to buyer, there is a paragraph that was the statewide forms committee added a paragraph on that as well, kind of just giving the buyer a heads up that it is illegal to do this in Maryland, but just be aware the seller may be making an audio recording even if they're not supposed to. So that's what's in the documentation. I guess as a practical matter, obviously this is more important, particularly on the buyer side. Just be mindful of that if you're walking through a property with your buyer. Make sure your buyer is aware of it. I used to say have that conversation on the front porch, but now with all these security things that can record the front porch, I wouldn't even say that. I would say have the buyer sort of be mindful while they're in the property, while you're on the front porch, maybe when you're back at the office or on the telephone after the seeing the property. That's maybe when you would have the real conversation about what the buyer really thinks. Again, you would be giving up leverage if the buyer's all excited and says, and the seller becomes aware of that.
Yeah.
They lose some leverage in the negotiations. Is there anything else to add, Colette?
What about, a lot of people ask, is a notice, if a seller posts a notice up on the, somewhere about the property in a conspicuous place, is that consent?
Yeah, that's a good point. Actually, no, it's not. Notification is not consent. So it does have to be a consent, knowing, informed consent, whatever that should be, something in writing signed by the buyer where they would agree, or whoever's touring the house, not necessarily a buyer, a prospective buyer, I guess I should say. They would have to consent in writing to that. So that's a good point.
Yeah. And what about penalties? Any idea what the penalties are for violation of this?
It's pretty serious. This is actually the wire fraud, wiretapping statute, believe it or not. And the seller could be, I don't remember the number off the top of my head, but there are significant penalties, fines that could be imposed on the seller, and believe it or not, potentially imprisonment. So this is something that it's a criminal statute. It shouldn't be treated lightly or taken lightly. That's something I think the statewide forms committee might be looking at, maybe to include the penalties in that language, just to kind of really bring it home for the sellers, to make them aware that they're serious about this, and you really should not make these audio recordings.
Yeah, as a matter of fact, Kathleen, we have it as a proposal on the agenda for the statewide forms committee to consider modifying and maybe putting some more information in there about that, maybe talking about the penalties and so forth.
Okay, so, good. That way maybe the sellers will take it more seriously.
Yeah.
We'll see. Fingers crossed.
All right. I'll take this one. I represented a seller in 2015. The property sustained damage to the attic as a result of a fire caused by lightning. The property has been restored. Must the fact that a fire occurred back in 2015 be disclosed to prospective buyers? So I think this is really a good question, because it brings up the discussion not just of latent defects, but also of material facts. So I think it's important to at least go with definition of both, and see who's obligated to disclose which. So we're talking about latent defects, and that's under the real property article, and we know that sellers are obligated to disclose known latent defects, all right? And latent defect is what? A material defect in the property that is hidden and could pose harm. So real property article 10.702, sellers disclose known latent defects. There's also a disclosure obligation, as you all know, that licensees have under the Brokers Act, and that is that licensees are obligated to disclose any material facts that they know or should know that relate to the property. Now, we always make the distinction between a latent defect and material defect. A material fact, as I should say, it's not material fact, is a much broader category of facts, right? So anything that would affect a buyer's decision or tenant's decision to purchase or lease the property, or the terms upon which they would purchase or lease the property, and so forth. So our opinion here is, okay, so the seller has taken steps to restore the property, and maybe they had a licensed contractor do everything. First question is, would the seller have to disclose this as a latent defect? And so the saying maybe not. As the seller's done what they needed to do, it's no longer defect. So the seller's obligation to disclose maybe goes away. But then you have to remember to ask the second part of that, which is this a material fact that a licensee would need to disclose to prospective buyers? And I think Kathleen and I are on the same page in saying that, yes, we believe that this is a material fact that a buyer, we think a reasonable buyer, would want to know this information before entering into the transaction or entering into the contract.
I would agree. And sometimes say this in class. I don't want to say you should do it because you're going to get caught, but
right.
chances are, think about it, when the buyer is applying for homeowners insurance, trying to get homeowners insurance, they're part of the underwriting process. They're going to run a clue report, and they're going to find out that there was a fire on the property anyway. So chances are, the buyer is going to become aware of it at that point. And if any of you have been in this situation, you know how the buyer responds. It's a very, very poor reaction. They think, why didn't the seller disclose that? What else are they hiding? What else are they not telling me? So I think even just from a practical perspective, it's better if the seller or listing agent provides the information and presents it in the way that you want to present it. I mean, quite possibly it could be a positive if it's all new electrical, all new whatever, all permitted, all done by a licensed contractor. Maybe there's paperwork that, might be helpful. The buyer, it might make the buyer more comfortable. Possibly they might want to pay more if it's basically a brand new house.
Yeah. That's true. So there are, the benefits of, disclosing this information just upfront, and not making it appear as if you're hiding something. The other point about this fact pattern is that, sometimes they say, well, it's 2015, what is 2019, it's 4 years ago. Is that, does that impact the analysis? And I think 2015, I mean, certainly, if something happened, maybe in 1985, many, many years ago, perhaps, it's so far that it's just really not material. But I would say 2015 is fairly recent, and I would think we would go ahead and disclose.
I would agree with that. And I guess never mind, we're going to get to it in a couple of slides. Okay, that's good.
So we're good? All
yep.
right. Yeah, I'll take this one. So one of the neighbors told me that a murder was committed in my seller client's home. Must I disclose this information to prospective buyers? So there is a statute. So we just talked about material facts, right? There is a statute in the Brokers Act, in the section 17-322.1 or something like that. It says that information like this, murder, homicide, suicide, natural death, person has HIV or AIDS, passed away in the property, that is not considered a material fact under the Brokers Act. And so a licensee, if they don't voluntarily disclose this information, the Real Estate Commission wouldn't, prosecute them or come after them.
I think by definition, that's not a material fact, and you don't breach any duty by not disclosing it. When I teach a class, or when we talk about this in class, I do say for the listing agent, though, to be prepared. And maybe talk to your client about, if this question comes up, how would they like you to respond? Again, just sort of in the context of, the chances are the neighbor's going to be excited to tell the potential buyer that something bad happened in the property, just to be honest about it. So I think I would maybe have a conversation with the client to be prepared. How would they like you to respond if you are asked, just in case that comes up as the neighbors talk.
Yeah, that's typically how we find out about many material facts, right?
Exactly.
So, I think that for practical purposes, I think that really is a conversation that needs to be had with the seller.
Right.
Anything else you want to add here?
I think that's it.
Okay.
All right. What are real estate licensees' disclosure obligations concerning mold, unpermitted work, home inspections, and meth houses? Maybe we can both kind of go through this. The mold is basically the same analysis that we did, I think, 2 slides ago for the fire that occurred in the house.
Yeah.
The distinction would be between a latent defect and a material fact. If the seller has done whatever needed to be done to remediate the mold completely, meaning if it was say there was a roof leak and it was causing mold inside, if the seller replaced the roof and took out all of the moldy drywall or wood or whatever it was and completely replaced it, it is possible that there's no longer a defect. It may not be a latent defect, but I would say it's still a material fact that the buyer would want to be aware of.
I would absolutely agree on that. Anything substantial in that, mold is something that could seriously impact the prospective buyers or tenants' health.
Right.
So I would think that would be a material fact.
Okay.
Yeah.
Okay. The next one, unpermitted work. This is a hot topic right now, a smoking hot topic right now, particularly where agents maybe are purchasing property, or they're working with investors who are purchasing property and flipping it, basically, or fixing it up and reselling it. Oftentimes, those people's margins are pretty thin. They're really trying to cut costs and resell the property, as cost effectively as possible. Unfortunately, a lot of times that means they're not using licensed contractors and they're not pulling permits. And I understand from the mediators, I hear this is sort of a trend right now. There's been a lot of complaints filed recently, a lot of requests for mediation where the buyer finds out, I guess after settlement, that the seller did all this work and did not pull permits and didn't use licensed contractors. So again, kind of the same analysis again. If the seller tells you about it, if you're the listing agent, the seller tells you, I didn't pull permits, then you know about that. That would be a material fact, and you should disclose that.
Right.
Other than that, I would say it's known or should have known. If the seller doesn't tell you, but there's something in the house that kind of gives you a clue that perhaps the work wasn't done by people who knew what they were doing. Let's say there's a wire hanging from the ceiling. It's a live electrical wire or something. That would not be a good thing. That would be a bit of a red flag where you might have to, ask the seller, are you sure this was done by a licensed electrician? Whatever it was. So then you would be sort of on notice. You would know that the work was done without a permit. And again, that would give rise to your obligation to disclose that as material fact.
Yeah, I would agree.
Yeah.
What about home inspection? So that's another area where, seller may have to update the disclosure disclaimer statement. So if buyer A entered into contract with this home inspection contingency and, buyer A walked away under the contract, and now we've got this information in this report, the question is, what do we do with it? Are there any material facts in there? What are we disclosing here? And again, our position has been, number one, the fact is that a home inspector has said that these are issues, but we take the view that listing agent seller would need to go through that report, and anything that was mentioned by the inspector, we would say if it's a material fact, if it falls into that category, then it should be disclosed. And again, it's what the inspector is saying appears to be wrong with the property.
Right. I would agree with that. I would caution you all on this one to talk to your broker or your office manager if you have any questions. As Colette had pointed out, if there is something, if the seller is now aware of some latent defect that they were not aware of originally, obviously they're required to disclose latent defects. They should go back and amend their disclosure disclaimer statement. So even if they did a disclaimer, they would now be obligated to disclose whatever the latent defect is that they're aware of now. Anything in that report that you're aware of that's a material fact, you should disclose that. Our best recommendation is that you disclose that in writing.
Yeah.
I think most people would upload that with the disclosure disclaimer statement on Bright MLS. The only other question that comes up in connection with that here, Colette, let's talk about this just quickly. If the first buyer walks, they have provided a copy of the home inspection report to the seller, consistent with the addendum.
Right.
And is the seller, is the listing agent or seller, I suppose, able to provide a copy of that report in full to another buyer? What should they do, or what can they do with that report?
Well, that question comes up all the time. I think technically that report belongs to the buyer. So it's really, I think the key really is the information in the report that you want to review. I think as a courtesy, if you were going to disperse that report, I would get the first buyer's permission to do that.
Right.
But it's really the information that is in that inspection report that the seller would want to review to make sure there are not any latent defects or mentioned by the inspector, and the listing agent would want to review to make sure there are not any material facts, because they would need to disclose that information.
Right. And that's something I would say, talk to your broker, your office manager. Sometimes those home inspection reports, they're quite descriptive with their verbiage and their adjectives. So I would discuss that with your office manager or broker, how you want to disclose the facts that are in there. Yeah, material facts.
What about meth houses?
Meth houses, I have only been asked about that once or twice, and I think the thing that is different about meth houses, rather than just just a defect or whatever, I think meth houses, it really could be a health issue, a safety issue. I think there's gases or fumes or whatever it is that permeate the home and possibly even the exterior of the home, right? The ground.
That's my understanding.
Yeah.
Yeah, so even if in that situation, I think you would want to disclose because of the health concerns, if you're aware. Of course, obviously you have no idea then, but if you're aware that this kind of activity was going on in the property, I would think that you would need to disclose that.
I would agree. I think that. Do we have any more? I
don't think so.
No. Okay. We have another. This one comes up fairly often as well. If someone is holding a power of attorney for another person, is the person who has the power, the person who will be signing, are they exempt from the requirement to provide a disclosure disclaimer statement? And the short answer to that is basically no. Even if, like, say, Colette, you're the seller, you're going to be out of town, I'm a friend, and you have authorized me to be your power of attorney, so I'm going to fill out the disclosure disclaimer for you. I don't have any personal knowledge about the property or about what's going on with the property, but that basically doesn't matter. I would step into Colette's shoes. If Colette is a seller who would be required to provide the disclosure disclaimer statement, then I would be required to provide the disclosure disclaimer statement. The power of attorney isn't one of the categories that's exempt. If it's a trustee for a trust, they might be exempt. A fiduciary would be exempt. Bank-owned properties are exempt from providing the disclosure disclaimer. But if someone holding a power of attorney is not necessarily exempt just because of that status.
Right. And I think if there's ever any question about what types of transactions are exempt from 10-702, the disclosure disclaimer law, then you want to look at the first page of the disclosure disclaimer statement, and that will list the exempted transactions.
Good point. It's right there on the form.
Right.
Yeah.
Anything else to add there?
No, I think we're good. All right, I'll do this one. Is an attorney entitled to a commission for the purchase of his or her personal residence? This one comes up fairly often too.
I would say it does.
This was the concept where an attorney would be paid a commission. Under the Brokerage Act, a real estate license is required if you're going to provide real estate brokerage services. There are a few exemptions to that. One would be for an auctioneer. Another one is for an attorney. And a couple years ago, I think it was becoming clear that this was sort of being abused, basically, or interpreted more broadly than it was intended to.
Right.
We would hear situations where someone's, brother in North Carolina was an attorney and he helped me, therefore you should pay him a commission, or he should get a commission. And the legislature narrowed that down a few years ago. So now for an attorney to be entitled to a commission, there's a couple requirements. The attorney, first of all, has to be licensed in Maryland. So brother in North Carolina, mom in Texas, whatever it is, they're automatically not eligible. You have to be licensed in Maryland. You have to be providing real estate brokerage services for another person. So if I'm the attorney, I'm purchasing property. If I'm purchasing it individually, just one person, I would not be eligible for a commission because I'm not providing real estate brokerage services for another person. It's just for me. So that would make me ineligible as well. If it was me and my husband, me and my sister, whatever it was, then arguably I've satisfied that criteria. The final criteria, I think, is the most narrow. The attorney has to provide real estate brokerage services for another person, and that providing real estate brokerage services has to be part of their routine practice of law. And I think that narrows it a lot. The only attorneys I could think of would be maybe possibly a bankruptcy attorney, or maybe an estate attorney, a divorce attorney, possibly, where they would maybe be helping their clients in selling their home. In all honesty, I think most of those attorneys develop relationships with realtors, because they wouldn't have access to Bright MLS and access to multiple lists and get the property advertised. I think most of them develop relationships, but that would probably be the only law practice, I think, that would satisfy that criteria. A title company attorney is not providing real estate brokerage services. Remember that. The title company is providing settlement services.
That's a good point.
So the title company attorney would not be entitled to a commission either. I think, is that it for that one?
I think so.
All right. All right, I can do this one. I can talk for 3 hours on this one, but I won't.
Yes, let's talk for 3 hours. Let's
talk for 3 minutes instead. All right, service animals or emotional support animals. Must service animals be specially trained or certified? There's a difference, again, between a service animal and a support animal. A service animal does have to be specially trained and certified. An emotional support animal does not. And I think most of us typically think of a service animal when we're thinking about this. So that's why I think in our heads we sort of think they need a special certification and training, and they do not necessarily. Service animal, probably the easiest one to think of is someone who's blind or visually impaired. If they have a guide dog, a seeing eye dog, that's a pretty easy example. Those dogs are specially trained. They are certified. They know a lot. They can help people stop at red lights, cross the street, get on or off the subway, all kinds of things. So that's something that, like I said, that's the typical one for a service animal. Emotional support animal is covered under the Fair Housing Act. Someone with a disability and a disability-related need for an emotional support animal, they do fall under just the category of disability under the Fair Housing Act, and they have protections under the Fair Housing Act. So those animals do not need to be specially trained, and they don't need to be certified. So for that situation, if someone had a therapy cat, let's say, if someone had whatever, I don't know, anxiety or whatever it was, if they have a disability and a disability-related need for the animal, then they would be entitled to live or in the property, you know, rent the property, whatever, and have the animal there. So it could be a cat. They do have to be able to provide documentation if the disability is not obvious.
Right.
The agent is entitled to ask the person for documentation to establish that they have a disability and a disability-related need for the emotional support animal. Let's say that's sort of a more frequent question. And if they can provide a letter saying that they have a disability and a disability-related need for the animal, then the landlord would accept that applicant and their pet. The landlord can't say, I shouldn't even say pet, excuse me, the support animal.
Right.
If the landlord has a no pets policy, the landlord cannot enforce it because it's not considered a pet. The animal is not considered a pet. If the landlord typically would impose a pet deposit, the landlord cannot require a pet deposit if it's a service animal or an emotional support animal as well. Anything else on that I didn't cover?
So what about if the emotional support animal or service animal causes damage to the property? How do you deal with that?
That does come up. That's a pretty common question as well. And basically, 2 points, I guess. First, let's say if the person who's living there cannot control the animal, the emotional support animal, if they can't control the animal, if it's a dog, if the dog gets out in the neighborhood and is aggressive and barks at people or whatever, the landlord would be entitled to ask the person to control the animal. They are required to control the animal, even if it's an emotional support animal, even if it's a service animal. If the animal causes damage to the property, we're assuming a landlord-tenant situation, the landlord would be entitled to take money from the security deposit to cover those damage, just as they would with any other tenant.
Right.
It's not, they don't get a special pass or anything, any kind of preferential treatment with respect to damages.
Yeah, and I think just to do a point of clarification on that, this is under the security deposit law. It's damage beyond ordinary wear and tear.
Oh, right.
Damage beyond ordinary wear and tear. And the other question that typically comes up about this is, who's considered a health care provider? Is that term fairly, broad?
Yeah. Again, sort of the intention of this under the Fair Housing Act, it is intended to be broadly interpreted, and it's a little bit generous. It could be a medical provider, a therapist, a nurse, a social worker, possibly. It's fairly broad.
It is.
Yeah. I will point out one thing. This is just a heads up on some regulations that have been proposed here in Maryland. I know a lot of you who are listening probably have seen there's sometimes people can go online and pay $120 or whatever it is, and voila, 3 minutes later, they have a certificate saying that they have a disability and they have a emotional support animal or an assistance animal, whether or not they really have a disability or not.
Right.
Obviously, that's a horrible thing to do. But the state of Maryland, several of the boards in Maryland are imposing regulations on telemedicine or telehealth or teletherapy, I think it's called. The Board of Physicians has some regulations pending. The Board of Nursing has some regulations pending. I think it's the Board of Therapists and Counselors, I think, has regulations pending. Basically, if someone's going to be providing services to a Maryland resident, through an online service or doing it remotely or whatever it is, they're trying to rein that in a little bit, where the person would either have to be licensed in Maryland or work with someone who is licensed in Maryland.
Okay.
So I think their intent obviously is care about their patients and making sure that people who are being provided with medical services here in Maryland are being provided services by duly licensed people. I think maybe the unintended consequence of that for our purposes, I think that might help reduce the number of these, basically factories where you can go online and just type it in and get a certificate, because that would not be someone who's licensed in Maryland typically. And some of those regulations that are being proposed now, I think, would restrict or limit someone's ability to use those certificates in the state of Maryland. So we'll follow that, and we'll keep you posted as those regulations are implemented or as that develops. So that's just keep that in mind. That's on the horizon.
All right. Anything else? I think we're good on that one. Let's go on. We were just actually talking about this yesterday. Landlord-tenant update has the interest rate on security deposits recently changed. Kathleen, is it 3%?
No. Guys, if you've been in the business for a while, you remember it was 3% for a long time.
And was it in another jurisdiction where it was maybe Prince George's where it was a little bit more?
Yeah.
So.
But anyway, the way the law was changed a couple of years ago to I think our legislators recognized it didn't really make sense for landlords to be required to pay out 3% interest when there were no bank accounts that were paying 3% interest. So it changed a couple years ago, and the rate is set January 1st of each year. And for this year, the rate is a little bit higher than it was last year. Last year it was 1.83%. This year it's 2.6.
Yeah,
so that's
high,
yeah.
And just for everybody, so you know, there is, and hopefully you guys are all familiar with this, but there is a deposit calculator on the Maryland Realtors website, which we think is a really handy resource. All you do is you type in, you know, the date you received the deposit, the amount of the deposit, and then the end date for the lease.
Right.
And the calculator will actually, you know, calculate the interest rate due for the entire period of the lease.
Right.
Which is a great resource.
Right.
So.
And you can see it on the page. Actually, it'll show you the breakdown. If the tenant's been there for a long time, and at one point in time it was 3%, and then it'll show you the time period and the amount of interest rate that was charged for that time period. So the numbers very clearly explained.
Yeah. So that's great. All right, we'll go on.
The next one. Colette, you got this.
I will, yeah. And I'm not gonna go into too much detail because a lot of this information is already on the Maryland Realtors website. But some people, I go out and teach the classes, some people still are not aware of some of the new forms. So I just thought I'd highlight them. There is the first one there, the Escrow Agreement, and all these forms, just so everybody knows, all the forms that Maryland Realtors prepares are on our website under the statewide forms page. So if you don't see a form there, then we have not prepared that form. So just so you're aware of that. Also, we always will do, usually in October when we post the form, so we'll do a summary of changes and practice tips, some things we think, best practices and so forth, and just kind of an explanation of the forms. But just so you know, the three forms that were prepared for 2018, the Escrow Agreement, just typically the question about that is when do you even use this form? And this is really intended to be used in situations where the broker, the real estate broker, is not going to be holding the deposit. So the parties have elected in the contract that they're going to have the title company or an attorney hold the deposit. And our recommendation or best practice is in these situations where it's title company or some other escrow agent, not the broker, to have the buyer and seller execute an escrow agreement. And Kathleen, it's my understanding that is there some legislation in the General Assembly for 2019?
Yes, there's a proposal this year, just a requirement that anyone holding an earnest money deposit, that they would be required to have a written escrow agreement. They don't have to use ours necessarily, but there is a proposal this year that anyone holding money would have to have a written escrow agreement.
So great. So. Yeah. So that's great. So the form is there. The thing I think is very helpful about this form is that not only is the buyer and seller signing this form, the escrow agent is signing the form. So the escrow agent is bound to abide by the terms of the agreement with regard to, you know, mediation and making sure that parties and agents are alerted if if it's insufficient funds or what have you. And, you know, as far as
the check is timely deposited.
Exactly.
Right.
So all these things are kind of laid out here. We think this is a really helpful tool. So I won't belabor that. Go on to the buyer hold harmless agreement. This form is intended to be used in situations where the buyer is going to be purchasing a property sight unseen. And really it is just letting the buyer know, look, you really should do your due diligence. We're not home inspectors. We're not, surveyors, whatever. And so there's a whole section on that. And then ultimately, if the buyer decides to purchase the property based on, video on the internet or what have you, then they can't hold the buyer broker or buyer agent liable if they get into the property and doesn't satisfy their needs.
I would just jump in there and say this is a really good risk management documentation for you as a buyer's agent. And I know sometimes if you work with people who are investors, if they purchase a lot of properties and then fix them up and flip them, I think if you have a relationship with your client, chances are they're going to ask you, hey, you think I should buy this? Is this a good, and you just need to be careful. You don't want to be in a position where you're guaranteeing that it's going to be a good property or guaranteeing it's going to be profitable. So this is a good document. It just clarifies you're not a home inspector, you're not an appraiser.
Right.
They really should do their due diligence before they make the decision to move forward. So I suggest getting that and just keeping that in your file in every transaction with those in those kind of situations.
Yes, again, I think very, very useful. form, and certainly we're definitely seeing, the State Reform Committee saw a need for it. So, and then the last new form is the tenant occupied addendum, and I won't belabor this one, just really intended to be used in situations where the property is going to convey with a tenant in it. There are certain things that the new buyer would need to be aware of, for example, that they are now liable for the security deposit. So this form facilitates transfer of that, notification to the tenant that there is a new owner. This form facilitates that if there is a rental license required in that particular area, the buyer would be made aware of that and so forth. So again, I think a very useful form and needed for members.
Right. I would just throw one thing sort of assumed there is basically the best assumption to have is that if there's a tenant in the property, assume the property is going to be conveyed with the tenant in it. That's probably the best starting point.
Yeah.
If the tenant's going to be leaving, the parties need to have an understanding of what's going to happen, who's going to do the eviction, is the tenant going to stay or what. Some buyers think if they purchase a property, they can just walk over there after settlement and tell the tenant to leave. That is not true.
Yeah.
So that's what this document is really to make clear. That's not what happens, and to make sure that the buyer and seller do discuss all of these things.
Absolutely.
And the buyer will be given a copy of the lease and
so forth.
Yeah,
exactly.
et cetera.
Yeah. So again, I think very useful form. And the only other thing I'll say, certainly the consumer notice to buyer is not a new form, but the committee, the statewide forms committee, did add a couple of provisions. So you're aware the wire fraud through email, that's been a big issue still. Yeah. I don't know if you all have seen, there's an article in the Washington Post about the significant jump in fraud based on these false emails that go to prospective buyers and clients and so forth. So you really should have a conversation with your client, and hopefully most people are doing that now and saying, look, if you get a email that has some instruction changes or whatever, please contact me directly. Don't just follow the email. So that's there. There's a notice provision in the consumer notice about the deposit being held by an escrow agent. And again, that's just kind of if you're going to have somebody other than the broker hold it, the best practice is to, execute an escrow agreement. Right. And then, of course, the latest provision, the smoke alarm notice. And we've already, done quite a bit of education on smoke alarm law. But again, just a notice in that consumer notice to the buyer that the smoke alarm law has changed recently. So anything to add there?
No, I think that's pretty clear.
All right, let's go on.
Okay. Contracts here, I'll go ahead and do this.
Okay.
The buyer fails to appear at settlement. Seller wants to put the property back on the market, but the parties have not signed a release of contract. What are the seller's options? I think everyone knows, or maybe should know if you don't, that we have two forms for release of contract. There's a mutual release where both the buyer and the seller would sign it saying, yes, the contract is terminated. There also is a notice of unilateral termination of the contract that is appropriate for the parties to use in certain situations. Let's say the buyer, it's a condo or an HOA, the buyer has received the documents, is unhappy with the documents, the buyer could just use the unilateral termination there and just send that over to the seller saying, I'm terminating the contract.
Yes.
So this would be this here, if the buyer doesn't show at settlement, that's sort of an ideal, the perfect scenario for the seller to terminate the contract. The important part here is that the contract isn't terminated automatically on its own. The seller has to take action to terminate it. So basically, remember from your pre-licensing class, it's voidable, not void, right? So if the seller uses that notice of unilateral termination, the listing agent would send that over to the buyer's agent saying the seller's terminating the contract because whatever paragraph number that is, the buyers didn't show up for settlement on the scheduled settlement date. So that would terminate the contract. Time is of the essence. We still get questions on the legal hotline every once in a while where people sort of think that there's a little bit of a buffer zone after the settlement date. Well, they were supposed to settle on Friday, but the lender needed a little bit more time, and the buyer is going to be able to settle on Monday instead. So that should be okay. That's close enough. It's not okay. The settlement date, it's a date that's a firm date in the contract. If you know that your buyer is not going to be able to close on Friday, get an extension agreement, extend the settlement date out there. Don't keep your fingers crossed and hope that nothing's going to happen, or kind of assume that everything's going to be okay, because maybe the seller received another offer. The seller could send that notice of unilateral termination on Saturday and your buyer be out of luck.
That's right.
That is a valid termination at that point if you haven't reached another agreement to extend the settlement date. And I guess another key thing to remember here is terminating the contract or reaching an agreement to terminate the contract is not necessarily a decision or an agreement about what happens to the EMD.
That's right.
It's quite possible that the parties could agree to terminate the contract, a mutual agreement terminating the contract, but still fight about the EMD, quite frankly, or not have an agreement about the EMD.
Mm-hmm.
So it is possible to terminate the contract even if they have not reached an agreement about the EMD. I think sometimes the buyer will think, well, if I don't sign that, if I don't agree to the deposit, then the seller won't be able to sell the property again. Or the seller might think, well, I'm just not going to, whatever it is, I don't know, they don't want to agree for whatever reason. But if the buyer and seller cannot agree about the EMD, that does not prohibit the seller from marketing the property again, assuming the seller has validly terminated the contract or the parties have mutually terminated the contract. The seller could relist it, remarket again, and they could fight about that EMD for weeks or months or longer.
Yeah. And the only thing else that I would say about that is just to be aware that if a dispute does arise with respect to the deposit, if the parties use Maryland Realtors contract, then they are obligated to attempt to mediate that dispute. And,
right.
So that's one thing. So that's the party's kind of next step. And that's for any dispute that arises as a result of the transaction. The parties are obligated to at least attempt to mediate that dispute. And the other thing I'll just point out about the deposit, just so folks are aware, because we get a lot of questions about this 30-day letter, that if the broker is holding the deposit, the 30-day letter, what is that supposed to look like? There is in the broker policy manual template available on the Maryland Realtors website a sample 30-day letter that brokers can use to facilitate if that's something they choose to do.
Right. That's a good point. Thank you. We do get a fair number of questions about that on the legal hotline as well.
Right.
I think we're good there.
We're good there.
Yeah.
I'll take this one. When do I use the first-time homebuyer addendum? So, believe it or not, we still get questions about the first-time homebuyer provision of the contract. And so what I always try to explain to you, in fact, I just had a conversation about it last week. So folks are aware, if you look at paragraph 25 of the Maryland Realtor contract, and specifically paragraph 25B, remember that the first sentence under paragraph B is a statement of the law. So under section 14-104C of the Real Property Article, the entire amount of liquidation local transfer tax shall be paid by the seller of property that's sold to a first-time Maryland homebuyer unless there's an express agreement that liquidation tax or any state local transfer tax will not be paid entirely by the seller. Again, that is a statement of the law. The second sentence there, which is headed with liquidation local transfer tax, that is the express agreement contemplated in 14-104C. So the express agreement is in the body of the contract, which means that what does it say? Buyer is a first-time Maryland homebuyer. Buyer and seller expressly agree in accordance with 14-104C, the first sentence, Real Property Article, Annotated Code of Maryland, that payment of liquidation tax, local transfer tax shall be shared equally between the buyer and the seller, unless there's a first-time Maryland homebuyer transfer liquidation tax addendum attached. So the contract, the contract with the express agreement contained in it means that the first-time Maryland homebuyer and seller are agreeing to split. If the parties want to negotiate a different arrangement, then they need to incorporate the first-time Maryland homebuyer. And in any case, they need to make sure that that box checked on page 11 that indicates that the buyer's first-time homebuyer is checked.
Right.
Right. So again, if the parties are going to split, they do not need the first-time Maryland homebuyer addendum. If they want to negotiate any other arrangement, then they do need the addendum.
Right. You might get some pushback on that if you tell someone that, because we still get asked this question. The contract's been written that way for years.
Yeah, at least 10 years.
Yeah, but people are just used to seeing the first-time homebuyer addendum, and I think there still is a belief that it's necessary and it's required. It's only required if they're not going to split it 50-50.
That's correct.
Be firm. Get the message out. Thank you.
All right.
All right. Next.
All right. Let's go on. Let me do this one.
Sure.
I have two agency. I have two clients who want to submit offers on the same property. Can I represent both of them? Well, we think that this could create an incurable conflict of interest.
Right.
So hopefully your broker or manager has a policy in place in this situation. I would say the best practice here is to go to the broker and have the broker or branch manager appoint another agent in the company to represent one of those buyers. Right.
No, I would agree. That's the best policy. I shouldn't say this, but I did this in a class once, and someone said, well, how do you know which client to refer? And somebody said, the one who's not going to get accepted. I'm not saying that's advice. I'm just saying that I thought that was interesting.
That question was asked.
Yeah,
right?
Yeah.
All right, we'll go on. I'm going to take this one.
All right, procuring cause. We do get a fair number of questions on procuring cause on the legal hotline as well. Let's say the listing agent showed the property, but I have a signed buyer agency agreement. Who gets the commission? So this is really basically, I think, the gist of every procuring cause question that we're asked. The key, well, as far as procuring cause, everyone should understand that there's no sort of magic thing that you do. If you do this one thing, you're automatically the procuring cause. I think way back in the day, there was a threshold rule. Whoever walks the buyer across the threshold the first time was a procuring cause. That's no longer dispositive. That's one factor that might indicate you're the procuring cause or not. It's not like a slam dunk. Procuring cause will be determined. You might have to go to an arbitration with a panel before your local board, and that panel would make the determination as to who's the procuring cause, and it would depend on who's on the panel, what factors they would consider important. There's a lot of information in the NAR Code of Ethics and Arbitration Manual on this. We could give you more information if you want. You can contact the legal hotline. But the main thing from this question that we probably should focus on, I have a signed buyer agency agreement. Just the fact that you have a signed buyer agency agreement doesn't necessarily mean that you're the procuring cause, right? There's a difference between representation and procuring cause. So it's quite possible that you have a signed buyer agency agreement, which would obligate your buyer to pay you. That's a contractual agreement between, your buyer and the broker, quite frankly, but basically you will say. So the buyer is obligated contractually to provide compensation, but that doesn't mean that you're the procuring cause. The procuring cause, remember, that's going to be the compensation, the offer of compensation on Bright MLS, and that's the number there that's going to be paid to whoever's the procuring cause. And you may or may not be. If you have a buyer who maybe saw the property at an open house, really liked it, they spent an hour and a half there and talked to the listing agent, they're ready to go buy, they talk to a loan officer, whatever it is, then they drive past your office on the way home, pop in, you prepare an offer for them and send it over. It's possible you're the procuring cause, but it's also possible that you're not, particularly if you didn't bring them to the house, show them to the house, or work with them to get them in a position where they're ready to buy that particular property for that particular price. So just be careful about that. Just because you have a signed buyer agency agreement does not mean necessarily that you're the procuring cause.
That's right. And in fact, the manual very clearly says agency relationships in and of themselves do not determine entitlement to compensation. I always tell people when they have questions about procuring cause, number one, the 2019 NAR Code of Ethics and Arbitration Manual is available to download, the entire manual, 250-page manual. There is, as Kathleen said, a very good discussion of procuring cause, of what it means in this context, broker-to-broker situation, what the factors are that a arbitration panel considers. And in fact, I can tell you I believe for the 2019 manual, that discussion begins on page 158, around page 158. But I encourage folks to, if they ever have any questions about that, to take a look at that, look at the factors. It talks about what, agency relationships, open-ended questions and considering the entire course of events, admissibility, breaks in communication and abandonment, and estrangement. So all those factors are discussed and analyzed by a panel. So if you call the hotline, you will probably never hear us say it's you, broker A, is entitled. We will say it depends, and you have to really look at those factors, and we can't tell you what an arbitration panel would ultimately decide.
Right. So I would agree with that. Not a very satisfying answer, but that's the answer.
Yeah.
All right, we good on that one?
Yeah, I think so.
Okay. All right, the next one, what is the licensee's obligation when the deposit check bounces or is returned for insufficient funds? This comes up, I don't know if you pay attention, the Real Estate Commission has disciplined quite a few agents who, a variety of scenarios. One situation, there was the buyer handed a check to the buyer's agent for the EMD and said, by the way, don't deposit this, it's not going to clear. That's probably the worst extreme you could get. Then there are other situations where maybe the money is deposited and the check bounces, and sometimes the agent never notifies the other party. The obligation is pretty clear. The party should be notified.
Yeah.
The other party should be notified if the check has bounced. Again, if you're an office manager or broker, you should have a policy in place or procedures in place that your staff is aware of this, and they would alert you or alert the agents, both probably, to let you know if a check has been returned. But the parties should be aware. We still get calls on the legal hotline for this. We had a listing broker call in a few weeks ago, and the transaction had fallen apart. And only when the transaction fell apart did the listing side become aware that the buyer's agent, the buyer's broker, had never collected the EMD, or I think they maybe had collected it and it had bounced, and the buyer had never replaced it because they thought the transaction was going south. So the listing agent said, like, I guess the seller's out of luck, and the seller's not out of luck. That's the buyer's. If the contract says your brokerage is holding that EMD, you should be holding that EMD. And I can assure you, if that seller files a complaint with the Real Estate Commission, the buyer's brokerage or the buyer's agent is going to have to cut a check to that seller. I mean, assuming the transaction fell apart and the seller would have been entitled to the EMD. If they file a complaint with the Real Estate Commission, the seller will prevail. So don't let this happen. Make sure the parties are aware. If you're an office manager or broker, make sure you have clear policies in place where the parties are notified if the check is returned, or I guess maybe a wire or whatever it is. If there's insufficient funds for whatever reason, the parties would need to be made aware of it.
Yeah, I mean, I would say a best practice with the earnest money deposit is to not just confirm that the check, whatever was received, but that it cleared.
Yes.
Whatever it's the wire transfer, whatever it is, making sure that it was received and cleared.
Right.
So
I would say that's sort of, I guess, with what we talked about before with the escrow agreement, there are increasing number of transactions where the broker or brokerage is not holding the EMD. A title company might be holding it, but I would say the same thing that Colette just said. It's a good practice for the listing side to verify receipt and deposit, and basically that it has cleared, regardless of who's holding the EMD.
Yeah, absolutely.
Okay.
All right. I'll take this next one. Under licensing law, can I give a gift to my client base if they provide a referral? So I'll just say there's a really good discussion. Well, there's some guidance on this on the Real Estate Commission's website, but essentially referrals constitute providing real estate brokerage services. So you can't pay a referral fee to somebody who is not licensed. And does that include attorneys, Kathleen? Can you pay a referral fee to an attorney?
No. No.
So that you cannot do that. You cannot give a gift to a client, a former client, if they provide you with a referral.
Right. Okay.
Right.
I think most attorneys, if they're in a situation like we had discussed earlier, an estate attorney or a bankruptcy attorney, I think a lot of those attorneys, if they develop a relationship with a realtor where they're in a position where they are making a lot of referrals, a lot of them will go ahead and get their license. So
exactly.
they can legitimately, lawfully be paid a referral fee.
Yeah. So that's it. Providing referrals is part and parcel of providing real estate brokerage services.
Right.
You need a license.
All right. You get this one?
Yeah.
Okay.
Oh, yeah, I'll take this one. When is the seller required to provide the state and federal lead-based paint disclosure forms? So, all right, so both federal and state disclosure information is the federal law, which is the required disclosure, applies. The disclosure is required in situations where the property is constructed prior to 1978. Right, so residential property constructed prior to 1978, then the seller is obligated to provide the federal lead disclosure form. Now, the state form is not a mandated form, but we believe it's a best practice to provide both in situations where the property is constructed prior to 1978, because the buyer may want to use that property as an investment property or a rental property, and that information on that Maryland Lead Poisoning Prevention Program disclosure would be that that buyer would want to have about whether or not the property is registered with MDE and so forth. So again, the federal law comes into play when property is constructed prior to 1978, residential properties constructed prior to 1978, and we recommend that you give, or that the seller give, or the owner give both the federal lead and the Maryland lead poison prevention program disclosure.
All right. I think, is that our last?
Is that it?
Question?
Yes,
Yeah.
it is.
I think we had, we had questions from the participants?
Yes, we have a few questions, and we have about 10 minutes to go over as many as we can. Is that okay with you guys?
That's great, sure.
Perfect. Okay, so the first question we have is, recently a buyer client insisted he did not have to provide a good faith deposit with the offer. Is this legal?
Actually, the buyer's correct. It's not required. Right. Yeah, it's not. You can have a valid enforceable contract without an EMD, so that's not legally required. However, if the contract says there's going to be an EMD, then he would have to do it. So I've seen situations, often with a short sale transaction, where the buyer might submit the offer, the seller might accept it. It may take the lender a significant period of time to decide if they're going to approve it or not. Often in those transactions, the buyer doesn't want to make an EMD up front. They might want to, or maybe they'll pay $1 or $100 or something, and they'll pay the real deposit once they've obtained the approval, the short sale approval from the lender. So that's sort of a situation where that might come up. The contract is set up where they could put in 0 for the EMD. They could do a 2-part deposit as well, with a smaller deposit up front and then a second deposit and an additional deposit in a larger amount. So the buyer is actually correct. I think in the real world, why that doesn't happen as often, I think just from the seller's perspective, if the seller is receiving multiple offers and this person has made a $1,000 deposit, this person's got some skin in the game, basically, to use the term, and this person has a $5,000 EMD and this person has 0, I think the seller's perception, I think, would just be that it's very easy for that buyer to walk.
Right.
There's no incentive for them to stay in it, and I just think I think in the real world, the seller, that's not as attractive to a seller as the other offers would be. So, but legally, that buyer is correct. It's not actually legally required.
Yeah, the only thing I'll add is that the earnest money deposit is really just a showing on the part of the buyer that they're, motivated and serious in terms of moving forward in the transaction. Remember, when it comes to satisfying the elements to create a contract, consideration is the purchase price, right? It's the purchase price. That is the consideration. So, as Kathleen said, earnest money deposit is not required under contract law, but from a practical standpoint, it's what we do, right?
Right. All right.
Perfect. Okay, next question. As a broker, what are the liabilities, if any, to have a licensee that has his own property management company and runs sales through my brokerage? All property management is conducted through his company. Rental listings are also uploaded onto MLS through the brokerage. Thank you.
I can answer this one. I think this is not an uncommon situation. I think there are a number of brokerages where the broker, basically where the office does not conduct property management services. So the broker in this case, I think if you have an agent who is providing property management services through their own entity, their own LLC or whatever other business entity it might be, or even them personally, I think you have to have a clear distinction between the services the brokerage is providing and the property management services that agent is providing individually. The best case scenario, for risk management purposes, that agent, ideally, they would have their own LLC, a separate business name, separate business cards, that type of thing. And again, this is the perfect scenario. Ideally, they would not meet clients in your office. I know that might be tough to do, but you wouldn't want the client coming to your office to pay rent, for example. The issue, I guess, is they would be providing real estate brokerage services, typically up till the point where the lease is signed. So doing all of those services through the brokerage, I think, is how it's typically done. You would have those rental listings on Bright MLS under your broker's name, under the company name. But everything from that point forward, collecting rent, any maintenance thing, that would typically be done under the property management services. The other thing to keep in mind is talk to your E&O provider, because there may be E&O coverage for property management services if you do that as part of your team, your brokerage provides those services. If you do not provide property management services, there's not going to be any coverage under your E&O for that. So that agent who's providing property management services should be aware of that, and probably their best practice would be to obtain their own individual E&O coverage for those services. The only other thing that's a little bit weird is if a complaint is filed against that agent with the real estate commission because of property management issues, because the agent is licensed, the real estate commission will hear the complaint and will make a decision on that complaint, even if it involves property management activity. That's sort of a weird little thing, but there's no license for property management. It's not required. There's no Maryland property management license. So it ends up with sort of an odd result there where an agent could be penalized or have a fine imposed against them for strictly property management issues. So again, that's why you as the broker be clear that that is not being done under your umbrella. You want to make sure that you as the broker are not going to be responsible for that. So I would suggest talking to your E&O carrier to make sure that that's clear, and maybe even consult with your attorney to make sure your policy and procedure manual is clear, that those property management services are being provided separately from your brokerage.
Yeah, because you don't want to have a situation where the broker is, has some liability for these property management services that are not even covered under the brokerage.
So you want to have them as separate as possible.
Right.
Perfect. Perfect. Next question we have is, must an applicant for a rental disclose that they have an emotional support animal on their rental application?
Well, I think I don't even know if most of the applications have a box for that necessarily, but ideally they should, because if it's, it doesn't even matter if it's a pet or no pet property, but it's basically going to need an accommodation, I would assume.
Right.
If the landlord allows pets but charges a pet deposit, the landlord's going to need to know this isn't a pet.
Right.
It's an emotional support animal, and I will not be paying that deposit. You're not going to charge that deposit to me. So they should have that on the application. And I guess even if it's a no pet, if the property is advertised as no pets or it's indicated that the landlord does not accept pets, then obviously the applicant should indicate that on the application as well, that they have an assistance animal, emotional support animal, whatever you want to call it. And the landlord would have to treat that as a request for a reasonable accommodation, where they might have to modify or basically waive their no pet rule or pet deposit rule. So the applicant should indicate that on the application. It's possible that a situation may come up after the person has moved in, where there's some trauma or tragedy that comes up and they subsequently need an emotional support animal or a therapy animal that they did not initially. That would be different, obviously, but as soon as that need arose, they would submit documentation to the landlord. Again, it's a request for a reasonable accommodation. Yeah.
Okay, perfect. We have another question. What if the tenant legally owns a firearm and stores it in accordance with Maryland regulations?
If they are storing it
Yeah, I'm not aware of that. To be honest, I've never been asked that question. Off the top of my head, I don't see any issues with that.
Yeah. If it's in compliance with Maryland law.
If it's registered and stored legally, and consistent with Maryland law, I'm not sure that that's an issue. I'm just thinking from the landlord's perspective, it may be on their homeowner's insurance. I'm not sure if that would cause issues for them.
It could,
I would suggest that the landlord, maybe, or the listing agent, maybe discuss that with or have the client discuss that with their homeowner's insurance. That's the only possible issue I can see. Other than that, people are allowed to own guns. If you have a permit and you're owning it lawfully and storing it lawfully, I'm not sure that I've never been asked that question. I haven't heard of any. I should knock wood. I haven't heard of any issues or problems with that.
Yeah, I haven't either. I haven't heard of anything, but.
Whoever asked the question, feel free to contact the legal hotline if there's additional facts that we should be aware of.
We can do some additional research on that as well, just to see.
Okay, perfect. We have time for a couple more questions. Let's see. Is there a difference between a gift and a referral fee for past clients? For example, can I take a former client out to lunch or send a $25 gift certificate as a thank you?
The commission is something nominal, a nominal kind of thank you may be okay, but a gift is of value would be, I think, considered compensation.
Yeah, I think, is it tied to a referral? I think it's kind of what it comes down to. If you give all of your clients at settlement, you give them all a gift card or take them all out to lunch or something, I think that would be okay. But if you only do that for clients who send you a referral or send you a friend, then that would be a problem.
Yeah.
So you can buy a ton of gift cards. You can't just buy a handful of gift cards just for the people who give you referrals. It can't be tied to a referral. That's basically the concept.
Yeah, that's pretty clear too. That's the referral.
Yeah. All right. Do you have another one, Jessica?
Yes. How does a landlord earn 2.6% on security deposit money?
How do they earn it?
That's the legal rate.
What's this? Tell me, and we'll all know. I don't. I'm not sure that banks are paying that either, but that is what the legal rate is. There was a formula put in place. It's adjusted January 1 of every year, and
that's the legal rate. So that's the law.
Yeah.
You know, whether banks are, as Kathleen said, whether banks are actually paying that.
Yeah.
That's the legal rate.
Yeah. And again, just everybody is probably aware of this, but the legal rate is the legal rate. The landlord can't strike through that in the lease and put 0. The legal rate is the legal rate. So that's unfortunately, the landlord is kind of stuck with it.
Yeah.
Even if they're not earning that, they still have to pay that.
Yeah. And there is in fact a provision under the security deposit law that says that the provisions cannot be struck.
Right. Right.
Right. So.
All right, next question. Let's see. I think she meant, is it legal for agents to write an EMD check for a property?
On behalf of?
If they're buying it. Other than that, no. No, talk to your office manager or broker. That's a very bad idea.
That's a very risky, you don't want to,
do that.
No.
Okay, perfect. Let's see. Okay, let's see. Does a landlord have to abide by the fair housing regulation to allow service/emotional support animals for short-term rentals, a month, a week, etc., in a resort community?
I believe so.
I don't.
Oh, for short-term rentals?
Short-term rentals. I don't believe they do.
I'd have to
we have to double check on that one. We have a difference of opinion here. I'm thinking they don't, but I'm not sure what the cutoff is. But if it's 30 days, whatever it is, what's considered a short-term rental? It has to be. What does it have to be? It has to be considered a residence. Whoever asked the question, contact the legal hotline.
Yeah,
I don't remember the details off the top of my head, but there are requirements, and I think it's a little bit of a gray area. It's not, the laws wouldn't apply to a transient area. If you're there for a day, a hotel for a day or something, it wouldn't necessarily be required. But if it's more of a residence where you're living, then it might be. So it's a little bit of a gray area. Contact the legal hotline. We can get a little bit more detailed information for you on that.
Yeah, and we don't have a difference of opinion.
We don't.
We're just thinking out loud.
There you go. Thank you.
We're thinking out loud.
I agree.
Well, thank you so much, ladies, for speaking on behalf of Maryland Realtors and answering all these questions. You guys have been absolutely wonderful, and we definitely look forward to having you guys again.
All right. Thank you.
Thank you.
Thank you, everyone, for participating.
All right, guys. Have a wonderful day.
All right. You too. Have a great day. Take care.
Bye.